Hello everyone. Today I'm going to explain a very important topic. The topic is not important only for the syllabus purpose, but it is also very much important for our lives also. Man has rightly been described as a social animal. As a social being, he comes into contact with large number of people. If his conduct towards their fellow being is injurious, it must be regulated. For example, if he beats another person and takes away his property, the state in that case will protect the life and the interest of the victim. Therefore, to maintain the law and order in the society, it is very important for the state to regulate the conduct of the people. This is done by the state by making certain rules and regulations. These rules and regulations are called law. In the same way, I'm here to explain you about the business law, and business law is related with the activities like selling and purchasing. So here, through my PPT, you can very much understand about the few terms of the Indian Contract Act 1872. So let's go and learn something about the contract.
Definition and nature of a contract. Indian Contract Act 1872. Introduction. This act name is Indian Contract Act 1872. The act came into force with effect from 1st September 1872. This act applied to whole India except the state of Jammu and Kashmir. This act describes the general laws that govern the business contracts is formed in India. The act does not contain all the laws governing all possible kind of contract. History of Indian Contract Act 1872. The Act as enacted originally had 266 sections divided into following groups. Number 1. General Principle of Law of Contracts, Section 1 to 75. Contracts relating to sales of goods, 76 to 124. Special kind of contracts, for example, indemnity, guarantee, bailment, pledge, 125 to 238. Contract relating to partnership, 239 to 266. Definitions. Number 1. Contract under section 2H, agreement under section 2E, promise under section 2B. Definition of a contract. This definition is given by the Indian Contract Act is defined as an agreement enforceable by law. There are two things जो हम यहाँ पे देख रहे हैं. Number 1 is agreement. Number 2 is enforceability. Agreement हम next slide में आपको बताएंगे definition के साथ. Enforceability means होता है legal obligation. Thus, there are two essential elements of a contract. The number 1 is agreement and number 2 is enforceability at law. That is called the legal obligations. Definition of an agreement. An agreement is defined in section 2E of the Indian Contract Act as promise or set of promises forming the consideration for each other. Agreements are two types. One is unenforceable and second is enforceable. Unenforceable contracts are those contracts which an aggrieved party cannot go to a law court and that is left at the mercy of the parties only. It is simply a gentleman's promise which may or may not be fulfilled by the promisor. Second is enforceable by law. All those agreements are said to be enforceable in which the aggrieved party has a right to approach a law court to get the agreement enforced and the other party is held liable either to perform the agreement or to face the consequences for breach of the contract. All these agreements which are enforceable is called the contract. Definition of promise. Promise is defined under section 2b as a proposal when accepted becomes promise. Proposal means offer and accepted means acceptance. It implies that the parties have a common intention about the subject matter or their agreement. This is called the common intentions. Common intention. Proposal means offer plus accepted means acceptance. And this is called the common intention. This is a very important thing and it requires two or more parties. Two or more parties, one party is called promisor and second party is called promisee. Promisor who makes a proposal, promisee who gives acceptance. Now, definition of consideration. Under section 2D of the Indian Contract Act defined as when at the desire of the promisor, B. the promisor or any other person, C. has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing something, such act abstains or promise is called consideration for the promise. Consideration. Consideration means something of value. कोई भी ऐसी चीज जिसकी कोई वैल्यू हो. सबसे ज्यादा वैल्यू तो किसकी होती है? मनी. और ये एक बेहतर सोर्स भी है. किसी भी कॉन्ट्रैक्ट को पूरा करने के लिए मनी इज अ वेरी suitable term or suitable consideration. Second is anything which anything which have the same value, like any asset. Asset के साथ एक exception आता है जिसको हम हमारे consideration के chapter में आगे पढ़ेंगे. ये बहुत इंपॉर्टेंट टर्म है. ऑल कॉन्ट्रैक्ट्स आर एग्रीमेंट बट ऑल एग्रीमेंट्स आर नॉट कॉन्ट्रैक्ट. इसको समझने के लिए चलिए लेट्स गो. एग्जाम्पल. मैंने आपको बोला ऑल कॉन्ट्रैक्ट्स आर एग्रीमेंट्स बट ऑल एग्रीमेंट्स आर नॉट कॉन्ट्रैक्ट. सो एग्रीमेंट्स, ये पूरा जो बॉक्स है हमारा, ये हो गया हमारा एग्रीमेंट. इसमें हमने डाल दी इन्फोर्सिबिलिटी. Enforceability. So agreement plus enforceability, that's called contract. अगर enforceability नहीं होगी तो वो contract नहीं होगा. Another example. A is a person who wants to sell his car to B. ये A है और ये B है. A wants to sell his car for rupees 2 lakhs. So A is giving a proposal. ठीक है. And if B accepts that and give his consent कि he is ready to buy, तो ये क्या बन जाएगा हमारा? एक वैलिड कॉन्ट्रैक्ट बन जाएगा. इन्होंने एक्सेप्टेंस दे दी अपनी. So it is become a contract because both the parties have same intentions. Both the parties are ready with the same thing. In this example, these 2 lakh rupees is called consideration. These 2 lakh rupees क्या है ये? Consideration. 2 लाख रुपीस की वैल्यू है ना, तो ये हमारा हो गया कंसिडरेशन. ए कौन हो गया हमारे? प्रोमिसर. बी क्या हो गए? वेरी गुड, प्रोमिसी. और सेल हिज कार क्या हो गया? प्रपोजल हो गया. सो एक वैलिड कॉन्ट्रैक्ट के लिए क्या क्या जरूरी है? कंसिडरे अग्रीमेंट. ये अग्रीमेंट है ना, बाइंग एंड सेलिंग. सो अग्रीमेंट प्लस, क्योंकि बाइंग एंड सेलिंग है तो ऑब्वियस सी बात है इसमें लीगल इन्फोर्समेंट होगा, लीगल ऑब्लिगेशंस होंगे. अगर ये अपनी कार दे रहे हैं इनको, तो इनकी भी ड्यूटी है कि इनको पैसे दें. सो कंसिडरेशन, और इसमें अगर हम लीगल ऑब्लिगेशन लगा दें, इन्होंने पैसे नहीं दिए या आधे पैसे दिए, तो क्या ये अपनी कार दे देंगे? नहीं, अपनी कार ये नहीं देंगे. तो लीगल ऑब्लिगेशन हो गया आपका. सो ये बन जाता है हमारा कॉन्ट्रैक्ट. एक और एग्जांपल समझते हैं. A is a person having 2 cars. One is Maruti 800 and second is Centro. A wants to sell his Maruti car and gives offer to B for buying. Now B wants to buy Centro. B wants to buy Centro. Here the confusion between the parties. What is the confusion? A wants to sell his Maruti car and B wants to purchase Centro car. यहाँ पे प्रॉपर दोनों ने एक दूसरे को कॉन्ट्रैक्ट नहीं बताया है. उन्होंने ये नहीं बताया, ए ने यहाँ नहीं बताया कि वो कौन सी कार बेचना चाहता है और बी यहाँ पे नहीं क्लियर कर रहा है कि वो कौन सी कार लेना चाह रहा है. सो दे बोथ आर नॉट हैविंग अ सेम इंटेंशंस. इसलिए ये एक वैलिड कॉन्ट्रैक्ट नहीं होगा, या फिर हम कह सकते हैं कि ये एक कॉन्ट्रैक्ट ही नहीं है. नो कॉन्ट्रैक्ट, बिकॉज एक वैलिड कॉन्ट्रैक्ट के लिए जरूरी है प्रॉपर प्रपोजल, प्रॉपर एक्सेप्टेंस. So in today's class What actually we studied? We studied about the कॉन्ट्रैक्ट. कॉन्ट्रैक्ट कैसे बनता है? अग्रीमेंट प्लस enforceability बाय लॉ. और अग्रीमेंट कैसे बनता है? एग्रीमेंट बनाने के लिए ज़रूरी है ऑफर या प्रपोजल प्लस एक्सेप्टेंस. और ऑफर और एक्सेप्टेंस के संग दूसरी चीज़ क्या ज़रूरी है? प्रॉमिस प्लस consideration. The person who make proposal is called promiser, and the who accepts the proposal in the same thing in the same sense is called promisee. So I hope in today's lecture you are very much know about the term of the Indian Contract Act, the basic concepts. Thank you so much for watching.